The first matter to come before us this morning is State of Ohio versus Amanda Velez. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve any time, I'm keeping the clock this morning, and if you let me know how much time you want to reserve when you get started, I can keep you apprised of the passage of time. We read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. I am Attorney Matthew Bobrowski here on behalf of the appellant, Amanda Velez. I do not believe I'm going to need to reserve any time for rebuttal. This case is the issue in this case was a charge and conviction of unlawful sexual conduct with a minor in violation of Ohio Code Section 290704A. Obviously, at trial, in fact, it was a jury trial. The jury found that Ms. Velez was guilty. And we fully are aware that at a jury trial, the jury acts as the fact finder and is allowed to sort the evidentiary wheat from the evidentiary chaff, to disbelieve and believe witnesses as they see fit according to the evidence, and to resolve conflicting stories as they see fit under the evidence. But what we believe here in the issue is that the jury lost its way. You cannot resolve these, make a decision that is contrary to the weight of the evidence. And in this case, we believe there are several elements when taken into context that show that the manifest weight of the evidence does not support a conviction. By way of just very brief context, this matter was in regard to a lesbian relationship between two parties, Ms. Velez and L.A., where L.A. was a minor. These events happened in 2011, 2012, and the alleged sexual conduct happened in April of 2012. After that, on May 26, 2012, L.A. gave a written report to the police detailing the sexual conduct that allegedly happened in April of 2012. Her parents also gave a written statement. It's important to understand that in this context, L.A., she faced a great deal of disapproval for being in a lesbian relationship with her parents, and that it even was against her own religion. And this kind of home life context has to be remembered in how she conducted herself over the course of interactions with the police. Only a few days later, on May 30th, 2012, she contacted the police department again and gave a videotaped interview with Detective Mark Pickering. And she was by herself at the time, and she asked, her first question to Detective Pickering was, will my parents hear this? And she said that I don't want her, meaning Ms. Velez, to go to jail for something she didn't do. And she then also said, the things I had on paper were because my parents pressured me. She told a different version of events in this interview, in which she said that the alleged sexual conduct did not happen. It may have been a dream. Then, on June 5th, on June 5th, she gave a second interview, third statement to the police that basically recanted the May 30th interview where she had exonerated Ms. Velez. And she claimed in trial that she was not pressured, she did not discuss the matter with her parents prior to giving the second interview. However, we argue that from the context, particularly from the home life, this seems to be rather improbable in that in face of such family pressure and such disapproval, that if she stated in her second interview that she was facing pressure, how does this work? What's also should be remembered here is that between the first statement to the police, the written statement, and the first recorded interview, she continued her relationship with Ms. Velez. They exchanged, she even received a birthday present, an iPod from her. And the state will mention that there were messages in the notes section of the iPod.
But consent doesn't matter, right?
Consent does not matter, and we've never, we're not trying to insinuate that consent mattered. What we're saying here is that the sexual conduct never happened, that the disapproval of the relationship escalated. I'm sorry.
Is there any chance that the parents were disapproving of the fact that their child continued to do something that she was told not to do? Just general disobedience would have been enough for them?
I believe that certainly is a possibility. And, however, in the context of the testimony from LA, the alleged victim, it seems like there was very, very much disapproval of the lesbian aspect of the relationship.
But from what I read in the transcript, there really was, the parents and the child really never had much discussion at all about it.
It seems to me that she works around it. My reading of it was that there was disapproval. However, the jury found that, obviously, that there was no discussion. But we believe that there was disapproval from the parents. The second point I wanted to bring up was how Detective Pickering himself conducted the investigation. He never interviewed either the other parties at the party, which is a little bit confusing. Admittedly, we understand that there's no requirement that this crime be corroborated. You know, if the witnesses, the victim's statement, it can be enough. However, we argue that with all these inconsistent statements, all these inconsistent stories, that in interviewing the other people at the party should have been, in the exercise of due diligence, done. And they were not done. And there also was no collection of physical evidence. Now, the state will obviously talk about the text messages, the iPod, and again, we come back to the fact that we don't dispute the fact that those text messages were sent, that those messages were in the iPod. What we do say is that messages, texting, even sexting, does not denote sexual conduct. You can make the inference, however, that is not evidence of sexual conduct, and there was no physical evidence. Now, we freely admit that he obviously would not be able to collect much physical evidence a month after a party, but still was not even attempted.
And who all testified at trial?
Quebec.
Well,
I
I'll narrow this.
I can
Did
listen.
any of these other witnesses that he did not interview come to testify on behalf of the defense?
SB and AH, I
Okay.
believe, both testified. I know he did not interview the male that was at the party, which was GK. He did not interview, let's see, did not interview
The mother whose party.
the party, no.
AH is the minor whose house the party.
Yeah, I'm sorry, I'm actually on the wrong
Okay.
page.
It's relevant right now to me just about who testified at trial, not
Who
necessarily who was interviewed.
Okay, yes, he did not interview GK or SD.
And they did not testify at trial either?
SD
did.
SD testified.
Okay, thank you.
The next point I wanted to get to was the testimony of AH trial. She was a friend of both Ms. Velez and LA. And now, while there was some insinuation that she was a closer friend to Ms. Velez, we would argue that she had no reason to lie at trial. And according to her testimony, she, being the only person unencumbered by a significant other at this party, kept tabs on them, had a fairly good idea of where everyone was during the course of that evening. Now, obviously, according to LA and SD, AH was intoxicated. But she disputes that. She says she only had a less than half, I believe, of a watered-down Four Loko alcoholic, sweet alcoholic beverage. She also states that she slept in the same bed that night with Ms. Velez in LA, and that when the girls at the party changed, they all changed in the same bedroom. That includes SD, AH, Ms. Velez and L.A. And even, the final point I'd like to make is that even the state's witness, SD, states that when she was in the bedroom with Ms. Velez and L.A., that she saw they were just merely sitting on the bed. Obviously, the jury can find their own way, but in this case, we believe that the weight of the evidence, when taken into full context, particularly when read looking at how L.A. changed her story over the course of the investigation, shows that the evidence was not sufficient to support a conviction in this matter. Thank you.
Thank you.
Your Honor.
Okay, please the court. My name is Natasha Barrera, and I represent the appellee of the state of Ohio in this matter. With regard to the manifest weight argument, it is correct, as Attorney Bromkowski has stated, that determinations with regard to credibility should be granted deference to the trier of fact because they were in the first-hand position of observing the witnesses as they testified. And here, what we have is L.A., who came in and testified, who was the victim in this matter, stating the first issue is the conflicting statements. First and foremost was the written statement, which is consistent with her second taped interview as well as her testimony at trial, that her and Velez on this day of, in April of 2012, that she lied to her parents, told them that she was going to be at SD's house for a sleepover, and this was a plan between all of these juveniles, and then SD actually told her parents, her father, that yes, she would be staying at her house. The two of them went over to AH's house where they were having this party. She stated that there was drinking, that they were watching some movies, and that at one point her and Velez went into AH's bedroom where they were alone from what I can tell, for most of the evening. And it was during that time in AH's bedroom that the sexual conduct did occur. And L.A. stated, when questioned about the inconsistency between that first taped interview and the second, as well as the written statement, is that she stated that she fully intended, when she went into that first taped interview, to lie, to try to protect Velez because she was in love with Velez and she did not want her to get into any trouble. She stated that after she made that taped statement, that she then contacted Detective Pickering back because she wanted to tell the truth, and then she proceeded to state what actually occurred in the bedroom during that second taped interview, which was consistent with the written statement previously provided.
Is there testimony regarding the motivation for contacting the detective back to tell the truth? Is there any testimony regarding the motivation for that?
From what I was able to gather is that she just felt bad that she lied during that first interview, and she just wanted to make sure that she told the truth at that point. And SD actually testified as well, and she was able to corroborate portions of LA's testimony in that she admitted that they did lie to LA's parents with regard to where she would be, and that they did go to the party, that they were there watching movies, but that at some point Velez and LA did in fact go into AH's bedroom and they were there for a significant period of time by themselves. Furthermore, there were, in fact, those text messages as well as the iPod that were introduced into evidence. Text messages showing their relationship and some text messages that were sexual in nature, as well as in the iPod there was a message which stated, you know, happy birthday, all you need to do is stick to the story, we made a great story, just stick to it, which is kind of indicating that that Velez was kind of involved in this story of the sexual conduct actually being some sort of dream that she stated during that first taped interview. That corroborates LA's testimony at trial. And in relation to the DNA evidence, obviously it being a month after between the reporting and the actual event, any sort of DNA evidence that could have been recovered would presumably not be there, as Detective Pickering stated, because of being showering and all of that over the course of a month. And lastly, with regard to AH's testimony, both SD and LA testified at trial that AH was drunk and actually vomited that night as a result. And as AH testified that she admitted that she was closer to Velez at the time of her testimony. She did state that they were all there. She indicated that because she was the only person in the relationship, in some sort of relationship at the party, that she was able to keep a constant eye on everyone that was at the house. However, she did admit periods of time where she went into the kitchen, where she didn't, following her mother, that she obviously was not able to keep an eye on anyone there. And although she did deny drinking, obviously we had the testimony of the other two witnesses. And at the end of it all, credibility determinations are for that of the jury. And the state would ask that, because here the jury clearly made the determination in finding Ms. Velez guilty, that they believed that LA and SD's testimony, the state's version of events, was the credible and what actually transpired that evening, that should be upheld with regard to this matter. If there are no further questions.
Thank you.
Thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be linked to through the 9th District website. Thank you.